The significance of a cut motion lies in a. Facilitating the initiation of concentrated discussion on a specific demand for grant, and b. Upholding the principle of responsible government by probing the activities of the government. However, the cut motion do not have much utility in practice. They are only moved and discussed in the House but not passed as the government enjoys majority support. Their passage by the Lok Sabha amounts to the expressions of want of parliamentary confidence in the government and may lead to its resignation. On the last day of the days allotted for discussion and voting on the demands for grants, the Speaker puts all the remaining demands to vote and disposes them whether they have been discussed by the members or not. This is known as guillotine. 5. Passing of Appropriation Bill. The Constitution states that no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Accordingly, an appropriation bill is introduced to provide for the appropriation, out of the Consolidated Fund of India, all money required to meet a. The grants voted by the Lok Sabha. b. The expenditure charged on the Consolidated Fund of India. No such amendment can be proposed to the appropriation bill in either house of the parliament that will have the effect of varying the amount or altering the destination of any grant voted, or of varying the amount of any expenditure charged on the Consolidated Fund of India. The appropriation bill becomes the Appropriation Act after it is assented to by the President. This act authorizes, or legalizes, the payments from the Consolidated Fund of India. This means that the government cannot withdraw money from the Consolidated Fund of India till the enactment of the appropriation bill. This takes time and usually goes on till the end of April. But the government needs money to carry on its normal activities after 31st March, the end of the financial year. To overcome this functional difficulty, the Constitution has authorized the Lok Sabha to make any grant in advance in respect to the estimated expenditure for a part of the financial year, pending the completion of the voting of the demands for grants and the enactment of the appropriation bill. This provision is known as the vote on account. It is passed, or granted, after the general discussion on budget is over. It is generally granted for 2 months for an amount equivalent to 1/6 of the total estimation. 6. Passing of Finance Bill. The Finance Bill is introduced to give effect to the financial proposals of the Government of India for the following year. It is subjected to all the conditions applicable to a money bill. Unlike the Appropriation Bill, the amendments, seeking to reject or reduce a tax, can be moved in the case of Finance Bill. According to the Provisional Collection of Taxes Act of 1931, the Finance Bill must be enacted, i.e., passed by the Parliament and assented to by the President, within 75 days. The Finance Act legalizes the income side of the budget and completes the process of the enactment of the budget. Other grants. In addition to the budget that contains the ordinary estimates of income and expenditure for one financial year, various other grants are made by the Parliament under extraordinary or special circumstances. Supplementary grant. It is granted when the amount authorized by the Parliament through the Appropriation Act for a particular service for the current financial year is found to be insufficient for that year. Additional grant. It is granted when a need has arisen during the current financial year for additional expenditure upon some new service not contemplated in the budget for that year. Excess grant. It is granted when money has been spent on any service during a financial year in excess of the amount granted for that service in the budget for that year. It is voted by the Lok Sabha after the financial year. Before the demands for excess grants are submitted to the Lok Sabha for voting, they must be approved by the Public Accounts Committee of Parliament. Vote of credit. It is granted for meeting an unexpected demand upon the resources of India, when on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details ordinarily given in a budget. Hence, it is like a blank check given to the executive by the Lok Sabha. Exceptional grant. It is granted for a special purpose and forms no part of the current service of any financial year. Token grant. It is granted when funds to meet the proposed expenditure on a new service can be made available by reappropriation. A demand for the grant of a token sum, of 1 rupee, is submitted to the vote of the Lok Sabha and if assented, funds are made available. Reappropriation involves transfer of funds from one head to another. It does not involve any additional expenditure. Supplementary, additional, excess and exceptional grants and vote of credit are regulated by the same procedure which is applicable in the case of a regular budget. Funds. The Constitution of India provides for the following 3 kinds of funds for the central government. 1. Consolidated Fund of India, Article 266. 2. Public Account of India, Article 266. 3. Contingency Fund of India, Article 267. Consolidated Fund of India. It is a fund to which all receipts are credited and all payments are debited. In other words, a. All revenues received by the Government of India, b. All loans raised by the government by the issue of treasury bills, loans or ways and means of advances, and c. All money received by the government in repayment of loans forms the Consolidated Fund of India. All the legally authorized payments on behalf of the Government of India are made out of this fund. No money out of this fund can be appropriated, issued or drawn, except in accordance with a parliamentary law. Public Account of India. All other public money, other than those which are credited to the Consolidated Fund of India, received by or on behalf of the Government of India shall be credited to the Public Account of India. This includes Provident Fund deposits, judicial deposits, savings bank deposits, departmental deposits, remittances and so on. This account is operated by executive action, that is, the payments from this account can be made without parliamentary appropriation. Such payments are mostly in the nature of banking transactions. Contingency Fund of India. The Constitution authorized the Parliament to establish a Contingency Fund of India, into which amounts determined by law are paid from time to time. Accordingly, the Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President, and he can make advances out of it to meet unforeseen expenditure pending its authorization by the Parliament. The fund is held by the Finance Secretary on behalf of the President. Like the Public Account of India, it is also operated by executive action. Multifunctional role of Parliament. In the Indian politico-administrative system, the Parliament occupies a central position and has a multifunctional role. It enjoys extensive powers and performs a variety of functions towards the fulfillment of its constitutionally expected role. Its powers and functions can be classified under the following heads: 1. Legislative powers and functions; 2. Executive powers and functions; 3. Financial powers and functions; 4. Constituent powers and functions; 5. Judicial powers and functions; 6. Electoral powers and functions; 7. Other powers and functions. 1. Legislative powers and functions. The primary function of Parliament is to make laws for the governance of the country. It has exclusive power to make laws on the subjects enumerated in the Union List, which at present has 98 subjects, originally 97 subjects, and on the residuary subjects, that is, subjects not enumerated in any of the three lists. With regard to concurrent list, which has at present 52 subjects, originally 47 subjects, the Parliament has overriding powers, that is, the law of Parliament prevails over the law of the state legislature in case of a conflict between the two. The Constitution also empowers the Parliament to make laws on the subjects enumerated in the state list, which at present has 59 subjects, originally 66 subjects, under the following 5 abnormal circumstances: a. When Rajya Sabha passes a resolution to that effect; b. When a proclamation of national emergency is in operation; c. When 2 or more states make a joint request to the Parliament; d. When necessary to give effect to international agreements, treaties and conventions; e. When President's rule is in operation in the state. All the ordinances issued by the President, during the recess of the Parliament, must be approved by the Parliament within 6 weeks after its reassembly. An ordinance becomes inoperative if it is not approved by the Parliament within that period. The Parliament makes laws in a skeleton form and authorizes the executive to make detailed rules and regulations within the framework of the parent law. This is known as delegated legislation or executive legislation or subordinate legislation. Such rules and regulations are placed before the Parliament for its examination. 2. Executive powers and functions. The Constitution of India established a parliamentary form of government in which the executive is responsible to the Parliament for its policies and acts. Hence, the Parliament exercises control over the executive through question hour, 0 hour, half an hour discussion, short duration discussion, calling attention motion, adjournment motion, no confidence motion, censure motion and other discussions. It also supervises the activities of the executive with the help of its committees like Committee on Government Assurance, Committee on Subordinate Legislation, Committee on Petitions, etc. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. As a part of collective responsibility, there is individual responsibility, that is, each minister is individually responsible for the efficient administration of the ministry under his charge. This means that they continue in office so long as they enjoy the confidence of the majority members in the Lok Sabha. In other words, the Council of Ministers can be removed from office by the Lok Sabha by passing a no confidence motion. The Lok Sabha can also express lack of confidence in the government in the following ways: a. By not passing a motion of thanks on the President's inaugural address; b. By rejecting a money bill; c. By passing a censure motion or an adjournment motion; d. By defeating the government on a vital issue; e. By passing a cut motion. Therefore, the first function of Parliament can be said to be to select the group which is to form the government, support and sustain it in power so long as it enjoys its confidence, and to expel it when it ceases to do so, and leave it to the people to decide at the next general election. 23. 3. Financial powers and functions. No tax can be levied or collected and no expenditure can be incurred by the executive except under the authority and with the approval of Parliament. Hence, the budget is placed before the Parliament for its approval. The enactment of the budget by the Parliament legalizes the receipts and expenditure of the government for the ensuing financial year. The Parliament also scrutinizes government spending and financial performance with the help of its financial committees. These include Public Accounts Committee, Estimates Committee and Committee on Public Undertakings. They bring out the cases of illegal, irregular, unauthorized, improper usage and wastage and extravagance in public expenditure. Therefore, the parliamentary control over the executive in financial matters operates in 2 stages: a. Budgetary control, that is, control before the appropriation of grants through the enactment of the budget, and b. Post-budgetary control, that is, control after the appropriation of grants through the 3 financial committees. The budget is based on the principle of annuity, that is, the Parliament grants money to the government for one financial year. If the granted money is not spent by the end of the financial year, then the balance expires and returns to the Consolidated Fund of India. This practice is known as the rule of lapse. It facilitates effective financial control by the Parliament as no reserve funds can be built without its authorization. However, the observance of this rule leads to heavy rush of expenditure towards the close of the financial year. This is popularly called as March rush. 4. Constituent powers and functions. The Parliament is vested with the powers to amend the Constitution by way of addition, variation or repeal of any provision. The major part of the constitution can be amended by the parliament with special majority, that is, a majority of the total membership of each house and a majority of not less than 2/3 of the members present and voting in each house. Some other provisions of the constitution can be amended by the parliament with simple majority, that is, a majority of the members present and voting in each house of parliament. Only a few provisions of the constitution can be amended by the parliament, by special majority, and with the consent of at least half of the state legislatures, by simple majority. However, the power to initiate the process of the amendment of the constitution, in all the three cases, lies exclusively in the hands of the parliament and not the state legislature. There is only one exception, that is, the state legislature can pass a resolution requesting the parliament for the creation or abolition of the legislative council in the state. Based on the resolution, the parliament makes an act for amending the constitution to that effect. To sum up, the parliament can amend the constitution in three ways: A. By simple majority, B. By special majority, and C. By special majority but with the consent of half of all the state legislatures. The constituent power of the parliament is not unlimited, it is subject to the basic structure of the constitution. In other words, the parliament can amend any provision of the constitution except the basic features of the constitution. This was ruled by the Supreme Court in the case Vananda Bhati case, 1973, and reaffirmed in the Minerva Mills case, 1980, 24. 5. Judicial powers and functions. The judicial powers and functions of the parliament include the following: A. It can impeach the president for the violation of the constitution. B. It can remove the vice president from his office. C. It can recommend the removal of judges, including Chief Justice of the Supreme Court and the High Courts, Chief Election Commissioner, Controller and Auditor General to the President. D. It can punish its members or outsiders for the breach of its privileges or its contempt. 6. Electoral powers and functions. The parliament participates in the election of the president, along with the state legislative assemblies, and elects the vice president. The Lok Sabha elects its speaker and deputy speaker, while the Rajya Sabha elects its deputy chairman. The parliament is also authorized to make laws to regulate the elections to the offices of president and vice president, to both the houses of parliament and to both the houses of state legislature. Accordingly, Parliament enacted the Presidential and Vice Presidential Election Act, 1952, the Representation of People Act, 1950, the Representation of People Act, 1951, etc. 7. Other powers and functions. The various other powers and functions of the Parliament include: A. It serves as the highest deliberative body in the country. It discusses various issues of national and international significance. B. It approves all the three types of emergencies, national, state and financial, proclaimed by the President. C. It can create or abolish the state legislative councils on the recommendation of the concerned state legislative assemblies. D. It can increase or decrease the area, alter the boundaries and change the names of states of the Indian Union. E. It can regulate the organization and jurisdiction of the Supreme Court and High Courts and can establish a common High Court for two or more states. Ineffectiveness of parliamentary control. The parliamentary control over government and administration in India is more theoretical than practical. In reality, the control is not as effective as it ought to be. The following factors are responsible for this. A. The parliament has neither time nor expertise to control the administration, which has grown in volume as well as complexity. B. Parliament's financial control is hindered by the technical nature of the demands for grants. The parliamentarians, being laymen, cannot understand them properly and fully. C. The legislative leadership lies with the executive and it plays a significant role in formulating policies. D. The very size of the parliament is too large and unmanageable to be effective. E. The majority support enjoyed by the executive in the parliament reduces the possibility of effective criticism. F. The financial committees like Public Accounts Committee examines the public expenditure after it has been incurred by the executive. Thus, they do post-mortem work. G. The increased recourse to guillotine reduced the scope of financial control. H. The growth of delegated legislation has reduced the role of Parliament in making detailed laws and has increased the powers of bureaucracy. I. The frequent promulgation of ordinances by the President dilutes the Parliament's power of legislation. J. The Parliament's control is sporadic, general and mostly political in nature. K. Lack of strong and steady opposition in the Parliament, and a setback in the parliamentary behavior and ethics, have also contributed to the ineffectiveness of legislative control over administration in India. Position of Rajya Sabha. The constitutional position of the Rajya Sabha, as compared with the Lok Sabha, can be studied from three angles: 1 where Rajya Sabha is equal to Lok Sabha, 2 where Rajya Sabha is unequal to Lok Sabha, 3 where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. Equal status with Lok Sabha. In the following matters, the powers and status of the Rajya Sabha are equal to that of the Lok Sabha: 1 Introduction and passage of ordinary bills, 2 Introduction and passage of constitutional amendment bills, 3 Introduction and passage of financial bills involving expenditure from the Consolidated Fund of India, 4 Election and impeachment of the President, 5 Election and removal of the Vice President. However, Rajya Sabha alone can initiate the removal of the Vice President. He is removed by a resolution passed by the Rajya Sabha by an effective majority, which is a type of special majority, and agreed to by the Lok Sabha by a simple majority. 6. Making recommendation to the President for the removal of Chief Justice and Judges of Supreme Court and High Courts, Chief Election Commissioner and Controller and Auditor General. 7. Approval of ordinances issued by the President. 8. Approval of proclamation of all three types of emergencies by the President. 9. Selection of ministers including the Prime Minister. Under the Constitution, the ministers including the Prime Minister can be members of either house. However, irrespective of their membership, they are responsible only to the Lok Sabha. 10. Consideration of the reports of the constitutional bodies like Finance Commission, Union Public Service Commission, Controller and Auditor General, etc. 11. Enlargement of the jurisdiction of the Supreme Court and the Union Public Service Commission. Unequal status with Lok Sabha. In the following matters, the powers and status of the Rajya Sabha are unequal to that of the Lok Sabha. 1. A money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha. 2. Rajya Sabha cannot amend or reject a money bill. It should return the bill to the Lok Sabha within 14 days, either with recommendations or without recommendations. 3. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by the two houses. 4. A financial bill, not containing solely the matters of Article 110, also can be introduced only in the Lok Sabha and not in the Rajya Sabha. But, with regard to its passage, both the houses have equal powers. 5. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Lok Sabha. 6. The Speaker of Lok Sabha presides over the joint sitting of both the houses. 7. The Lok Sabha with greater number wins the battle in a joint sitting except when the combined strength of the ruling party in both the houses is less than that of the opposition parties. 8. Rajya Sabha can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of the Lok Sabha. 9. A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha and not by the Rajya Sabha. 10. The Rajya Sabha cannot remove the Council of Ministers by passing a no-confidence motion. This is because the Council of Ministers is collectively responsible only to the Lok Sabha. But, the Rajya Sabha can discuss and criticize the policies and activities of the government. Special powers of Rajya Sabha. The Rajya Sabha has been given 4 exclusive or special powers that are not enjoyed by the Lok Sabha. 1. It can authorize the Parliament to make a law on a subject enumerated in the state list, Article 249. 2. It can authorize the Parliament to create new All India services common to both the centre and states, Article 312. 3. It alone can initiate a move for the removal of the Vice President. In other words, a resolution for the removal of the Vice President can be introduced only in the Rajya Sabha and not in the Lok Sabha, Article 67. 4. If a proclamation is issued by the President for imposing national emergency or President's rule or financial emergency at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place within the period allowed for its approval, then the proclamation can remain effective even if it is approved by the Rajya Sabha alone, Articles 352, 356 and 360. An analysis of the above points makes it clear that the position of the Rajya Sabha in our constitutional system is not as weak as that of the House of Lords in the British constitutional system nor as strong as that of the Senate in the American constitutional system. Except in financial matters and control over the Council of Ministers, the powers and status of the Rajya Sabha in all other spheres are broadly equal and coordinate with that of the Lok Sabha. Even though the Rajya Sabha has been given less powers as compared with the Lok Sabha, its utility is supported on the following grounds. 1. It checks hasty, defective, careless and ill-considered legislation made by the Lok Sabha by making provision of revision and thought. 2. It facilitates giving representation to eminent professionals and experts who cannot face the direct election. The President nominates 12 such persons to the Rajya Sabha. 3. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the centre. Parliamentary privileges. Meaning. Parliamentary privileges are special rights, immunities and exemptions enjoyed by the two houses of Parliament, their committees and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the houses can neither maintain their authority, dignity and honor nor can protect their members from any obstruction in the discharge of their parliamentary responsibilities. The Constitution has also extended the parliamentary privileges to those persons who are entitled to speak and take part in the proceedings of a House of Parliament or any of its committees. These include the Attorney General of India and Union Ministers. It must be clarified here that the parliamentary privileges do not extend to the President who is also an integral part of the Parliament. Classification. Parliamentary privileges can be classified into 2 broad categories, 1 those that are enjoyed by each House of Parliament collectively, and 2 those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each House of Parliament collectively are, 1. It has the right to publish its reports, debates and proceedings and also the right to prohibit others from publishing the same. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of parliamentary proceedings without prior permission of the House. But this is not applicable in the case of a secret sitting of the House. 2. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, admonition or imprisonment, also suspension or expulsion, in case of members. 25.5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment and release of a member. 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. 7. The courts are prohibited to inquire into the proceedings of a house or its committees. 8. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: 1. They cannot be arrested during the session of Parliament and 40 days before the beginning and 40 days after the end of a session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. 2. They have freedom of speech in Parliament. No member is liable to any proceedings in any court for anything said or any vote given by him in Parliament or its committees. This freedom is subject to the provisions of the Constitution and to the rules and standing orders regulating the procedure of Parliament. 26.3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when Parliament is in session. Breach of privilege and contempt of the House. When any individual or authority disregards or attacks any of the privileges, rights and immunities, either of the member individually or of the House in its collective capacity, the offence is termed as breach of privilege and is punishable by the House. 27. Any act or omission which obstructs a House of Parliament, its member or its officer in the performance of their functions or which has a tendency, directly or indirectly to produce results against the dignity, authority and honour of the House is treated as a contempt of the House. 28. Though the two phrases, breach of privilege, and contempt of the House, are used interchangeably, they have different implications. Normally, a breach of privilege may amount to contempt of the House. Likewise, contempt of the House may include a breach of privilege also. Contempt of the House, however, has wider implications. There may be a contempt of the House without specifically committing a breach of privilege. 29. Similarly, actions which are not breaches of any specific privilege, but are offences against the dignity and authority of the House amount to contempt of the House. 30. For example, disobedience to a legitimate order of the House is not a breach of privilege, but can be punished as contempt of the House. Sources of privileges. Originally, the Constitution, Article 105, expressly mentioned two privileges, that is, freedom of speech in Parliament and right of publication of its proceedings. With regard to other privileges, it provided that they were to be the same as those of the British House of Commons, its committees and its members on the date of its commencement, i.e., 26 January 1950, until defined by Parliament. The 44th Amendment Act of 1978 provided that the other privileges of each House of Parliament, its committees and its members are to be those which they had on the date of its commencement, i.e., 20th June 1979, until defined by Parliament. This means that the position with regard to other privileges remains same. In other words, the amendment has made only verbal changes by dropping a direct reference to the British House of Commons, without making any change in the implication of the provision. 31. It should be noted here that the Parliament, till now, has not made any special law to exhaustively codify all the privileges. They are based on 5 sources, namely, 1. Constitutional provisions, 2. Various laws made by Parliament, 3. Rules of both the Houses, 4. Parliamentary conventions, and 5. Judicial interpretations. Sovereignty of Parliament. The doctrine of sovereignty of Parliament is associated with the British Parliament. Sovereignty means the supreme power within the state. That supreme power in Great Britain lies with the Parliament. There are no legal restrictions on its authority and jurisdiction. Therefore, the sovereignty of Parliament, parliamentary supremacy, is a cardinal feature of the British constitutional system. According to A.V. Dicey, the British jurist, this principle has 3 implications. 32.1. The Parliament can make, amend, substitute or repeal any law. De Lolme, a British political analyst, said, the British Parliament can do everything except make a woman a man and a man a woman. 2. The Parliament can make constitutional laws by the same procedure as ordinary laws. In other words, there is no legal distinction between the constituent authority and the legislative authority of the British Parliament. 3. The parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. In other words, there is no system of judicial review in Britain. The Indian Parliament, on the other hand, cannot be regarded as a sovereign body in the similar sense as there are legal restrictions on its authority and jurisdiction. The factors that limit the sovereignty of Indian Parliament are: 1. Written nature of the Constitution. The Constitution is the fundamental law of the land in our country. It has defined the authority and jurisdiction of all the 3 organs of the Union government and the nature of interrelationship between them. Hence, the Parliament has to operate within the limits prescribed by the Constitution. There is also a legal distinction between the legislative authority and the constituent authority of the Parliament. Moreover, to effect certain amendments to the Constitution, the ratification of half of the states is also required. In Britain, on the other hand, the Constitution is neither written nor there is anything like a fundamental law of the land. 2. Federal system of government. India has a federal system of government with a constitutional division of powers between the Union and the states. Both have to operate within the spheres allotted to them. Hence, the law-making authority of the Parliament gets confined to the subjects enumerated in the Union list and concurrent list and does not extend to the subjects enumerated in the state list, except in 5 abnormal circumstances, and that too for a short period. Britain, on the other hand, has a unitary system of government and hence, all the powers are vested in the centre. 3. System of judicial review. The adoption of an independent judiciary with the power of judicial review also restricts the supremacy of our Parliament. Both the Supreme Court and High Courts can declare the laws enacted by the Parliament as void and ultra vires, unconstitutional, if they contravene any provision of the Constitution. On the other hand, there is no system of judicial review in Britain. the British courts have to apply the parliamentary laws to specific cases, without examining their constitutionality, legality or reasonableness. 4. Fundamental rights. The authority of the Parliament is also restricted by the incorporation of a code of justiciable fundamental rights under Part 3 of the Constitution. Article 13 prohibits the state from making a law that either takes away totally or abrogates in part a fundamental right. Hence, a parliamentary law that contravenes the fundamental rights shall be void. In Britain, on the other hand, there is no codification of justiciable fundamental rights in the Constitution. The British Parliament has also not made any law that lays down the fundamental rights of the citizens. However, it does not mean that the British citizens do not have rights. Though there is no charter guaranteeing rights, there is maximum liberty in Britain due to the existence of the rule of law. Therefore, even though the nomenclature and organizational pattern of our Parliament is similar to that of the British Parliament, there is a substantial difference between the two. The Indian Parliament is not a sovereign body in the sense in which the British Parliament is a sovereign body. Unlike the British Parliament, the authority and jurisdiction of the Indian Parliament are defined, limited and restrained. In this regard, the Indian Parliament is similar to the American legislature, known as Congress. In USA also, the sovereignty of Congress is legally restricted by the written character of the Constitution, the federal system of government, the system of judicial review and the Bill of Rights. Table 22.5 Allocation of seats in Parliament for states and union territories, 2019. No states UTs. No of seats in Rajya Sabha. No of seats in Lok Sabha. I states. 1 Andhra Pradesh 1125. 2 Arunachal Pradesh 12. 3 Assam 714. 4 Bihar 1640. 5 Chhattisgarh 511. 6 Goa 12. 7 Gujarat 1126. 8 Haryana 510. 9 Himachal Pradesh 34. 10 Jharkhand 614. 11 Karnataka 1228-12. Kerala 920-13. Madhya Pradesh 1129-14. Maharashtra 1948-15. Manipur 1216. Meghalaya 1217. Mizoram 1118. Nagaland 1119. Odisha 1021-20. Punjab 713-21. Rajasthan 1025-22. Sikkim 1123. Tamil Nadu 1839-24. Telangana 717-25. Tripura 1226. Uttarakhand 3527. Uttar Pradesh 3180-28. West Bengal 1642-2. Union Territories 1. Andaman and Nicobar Islands 1. 2 Chandigarh 13. Dadra and Nagar Haveli 14. Daman and Diu 15. Delhi, the National Capital Territory of Delhi, 37. 6 Lakshadweep 17. Puducherry 118. Jammu and Kashmir 45. 9 Ladakh 1. 3 Nominated members 12-2. Total 245545. Table 22.6 Seats reserved for SCs and STs in the Lok Sabha, 2019. Name of the state union territory total reserved for the scheduled castes. Reserved for the scheduled tribes. I states. 1 Andhra Pradesh 2541. 2 Arunachal Pradesh 2. 3 Assam 1412. 4 Bihar 465. Chhattisgarh 1114. 6 Goa 27. Gujarat 2624. 8 Haryana 1029. Himachal Pradesh 41. 10 Jharkhand 1415. 11 Karnataka 2852. 12 Kerala 2213. Madhya Pradesh 2946. 14 Maharashtra 4854. 15 Manipur 21. 16 Meghalaya 22. 17 Mizoram 11. 18 Nagaland 119. Odisha 2135. 20 Punjab 13421. Rajasthan 25443. 22 Sikkim 123. Tamil Nadu 39724. Telangana 1732. 25 Tripura 21. 26 Uttarakhand 5127. Uttar Pradesh 801728. West Bengal 4210-2. 2 Union Territories. 1 Andaman and Nicobar Islands 1. 2 Chandigarh 13. Dadra and Nagar Haveli 11. 4 Daman and Diu 15. Delhi, the National Capital Territory of Delhi. 7-1. 6 Lakshadweep 11. 7 Puducherry 18. Jammu and Kashmir 5. 9 Ladakh 1 total 543 84 47. Table 22.7 Durations of the Lok Sabha, from first Lok Sabha to present Lok Sabha. Lok Sabha duration remarks. First 1952-1957 dissolved 38 days before expiry of its term. Second 1957-1962 dissolved 40 days before expiry of its term. Third 1962-1967 dissolved 44 days before expiry of its term. Fourth 1967-1970 dissolved 1 year and 79 days before expiry of its term. Fifth 1971-1977 term of the Lok Sabha was extended 2 times by 1 year at a time. However, the House was dissolved after having been in existence for a period of 5 years, 10 months and 6 days. Sixth 1977-1979 dissolved after having been in existence for a period of 2 years, 4 months and 28 days. Seventh 1980-1984 dissolved 20 days before expiry of its term. Eighth 1985-1989 dissolved 48 days before expiry of its term. Ninth 1989-1991 dissolved after having been in existence for a period of 1 year, 2 months and 25 days. 10th 1991 11th 1996 1997 dissolved after having been in existence for a period of 1 year, 6 months and 13 days. 12th 1998 dissolved after having been in existence for a period of 1 year, 1 month and 4 days. 13th 1999 dissolved 253 days before expiry of its term. 14th 2009 15th 2009 2014 16th 2014 2019 17th 2019 continuing. Table 22.8 Speakers of the Lok Sabha, from first Lok Sabha to present Lok Sabha. Lok Sabha name tenure, remarks, first 1. Ganesh Vasudev Mavlankar 1952 to 1956, died. 2. Ananthasayanam Iyengar 1956 to 1957. Second Ananthasayanam Iyengar 1957 to 1962. Third Hukum Singh 1962 to 1967. Fourth 1. Neelam Sanjeeva Reddy 1967 to 1969, resigned. 2. Godial Singh Dhillon 1969 to 1971. Fifth 1. Godial Singh Dhillon 1971 to 1975, resigned. 2. Bali Ram Bhagat 1976 to 1977. Sixth 1. Neelam Sanjeeva Reddy 1977 to 1977, resigned. 2. K.S. Hegde 1977 to 1987. Balram Jakar 1980 to 1985. 8th Balram Jakar 1985 to 1989. 9th Rabi Ray 1989 to 1991. 10th Shivraj Patil 1991 to 1996. 11th P.A. Sangama 1996 to 1998. 12th GMC Balayogi 1998 to 1999. 13th 1. GMC Balayogi 1999 to 2002, died. 2. Manohar Joshi 2002 to 2004. 14th Somnath Chatterjee 2004 to 2009. 15th Ms. Meera Kumar 2009 2014. 16th Ms. Sumitra Mahajan 2014 2019. 17th Om Birla 2019, till date. Table 22.9 Articles related to Parliament at a glance. Article No. Subject Matter General 79. Constitution of Parliament 80. Composition of the Council of States 81. Composition of the House of the People 82. Readjustment after each census 83. Duration of Houses of Parliament 84. Qualification for membership of Parliament 85. Sessions of Parliament, prorogation and dissolution 86. Right of President to address and send messages to Houses 87. Special address by the President 88. Rights of Ministers and Attorney General as respects Houses Officers of Parliament 89. The Chairman and Deputy Chairman of the Council of States 90. Vacation and resignation of, and removal from, the office of Deputy Chairman 91. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman. 92. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration. 93. The Speaker and Deputy Speaker of the House of the People. 94. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. 95. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. 96. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. 97. Salaries and allowances of the Chairman and Deputy Chairman and the Speaker and Deputy Speaker. 98. Secretariat of Parliament Conduct of Business. 99. Oath or affirmation by members. 100. Voting in Houses, power of Houses to act notwithstanding vacancies and quorum disqualifications of members. 101. Vacation of seats. 102. Disqualifications for membership. 103. Decision on questions as to disqualifications of members. 104. Penalty for sitting and voting before making oath or affirmation under Article 99 or when not qualified or when disqualified. Powers, privileges and immunities of Parliament and its members. 105. Powers, privileges, etc., of the Houses of Parliament and of the members and committees thereof. 106. Salaries and allowances of members. Legislative procedure. 107. Provisions as to introduction and passing of bills. 108. Joint sitting of both houses in certain cases. 109. Special procedure in respect of money bills. 110. Definition of money bills. 111. Assent to bills. Procedures in financial matters. 112. Annual financial statement. 113. Procedure in Parliament with respect to estimates. 114. Appropriation bills. 115. Supplementary, additional or excess grants. 116. Votes on account, votes of credit and exceptional grants. 117. Special provisions as to financial bills. Procedure generally. 118. Rules of procedure. 119. Regulation by law of procedure in Parliament in relation to financial business. 120. Language to be used in Parliament. 121. Restriction on discussion in Parliament. 122. Courts not to inquire into proceedings of Parliament. Legislative powers of the President. 123. Power of President to promulgate ordinances during recess of Parliament. Notes and references. 1. Westminster is a place in London where the British Parliament is located. It is often used as a symbol of the British Parliament. 2. See Table 22.5 at the end of this chapter. 3. An Anglo-Indian is a person whose father or any of whose other male progenitors in the male line is or was of European descent but who is domiciled within the territory of India and is or was born within such territory of parents habitually resident therein and not merely established there for temporary purposes. 4. See Table 22.5 at the end of this chapter. 5. This means that the number of Lok Sabha seats reserved in a state or union territory for such castes and tribes is to bear the same proportion to the total number of seats allotted to that state or union territory in the Lok Sabha as the population of such castes and tribes in the concerned state or union territory bears to the total population of state or union territory. 6. Under this, the President has made the Rajya Sabha term of office of members, Order, 1952. 7. The term of the 5th Lok Sabha that was to expire on 18 March, 1976, was extended by 1 year up to 18th March, 1977 by the House of the People, Extension of Duration, Act, 1976. It was extended for a further period of 1 year up to 18th March 1978 by the House of the People, Extension of Duration, Amendment Act, 1976. However, the House was dissolved on 18th January 1977, after having been in existence for a period of 5 years, 10 months and 6 days. 8. A minister in the union or state government is not considered as holding the office of profit. Also, the Parliament can declare that a particular office of profit will not disqualify its holder from parliamentary membership. 9. According to the prohibition of simultaneous membership rules, 1950, made by the President. 9A Section 3 of the Salaries and Allowances of Officers of Parliament Act, 1953, as amended. 9B Ibid. 9C Ibid. 9D Ibid. 9E Section 5 of the Salaries and Allowances of Officers of Parliament Act, 1953, as amended. 9F Ibid. 10 Tehuta Holohan vs. Zachailu, 1992. 11 In this context, V.V. Giri observed, the holder of an office provided with such extensive authority and power must discharge the duties of his office impartially. So impartiality is regarded as an indispensable condition of the office of the Speaker, who is the guardian of the powers and privileges of the House and not of the political party with whose support he might have been elected to the office. It is not possible for him to maintain order in the House unless he enjoys the confidence of the minority parties by safeguarding their rights and privileges. Powers of the presiding officers in Indian Legislature, in Journal of Constitutional and Parliamentary Studies, New Delhi, Vol. 2, No. 4 October. December 1968, p. 22, 12. For example, in the 13th Lok Sabha, Mr. Indrajit Gupta was appointed as Speaker pro tem on 20th October 1999 and remained in that office till 22nd October 1999 when the new Speaker, Mr. GMC Balayogi was elected. 13 Under Article 107, 3, of the Constitution, a bill pending in Parliament shall not lapse by reason of the prorogation of the Houses. Under Rule 336 of the Lok Sabha, a motion, resolution or an amendment, which has been moved and is pending in the House, shall not lapse by reason only of the prorogation of the House. 14 Subhash C. Kashyap, Our Parliament, National Book Trust, 1999 edition, p. 135136. 15 J.C. Johari, Indian Government and Politics, Vishal, Volume 2, 13th edition, 2001, p. 360. 15 A.T.K. Viswanathan, Editor, The Indian Parliament, Lok Sabha Secretariat, 14th edition, 2011, p. 21. 16 Subhash C. Kashyap, Our Parliament, National Book Trust, 1999 edition, p. 139141. 17 Ibid, p. 139. 18 Under Rule 64 of Lok Sabha, the Speaker may, on request being made to him, order the publication of any bill in the Gazette, although no motion has been made for leave to introduce the bill. In that case, it shall not be necessary to move for leave to introduce the bill, and if the bill is afterwards introduced, it shall not be necessary to publish it again. 19 For different kinds of veto, see, veto power of the President, under Chapter 17. 20 The Lok Sabha did not agree to the amendments made by the Rajya Sabha. A joint sitting was held on 6 May 1961. 21 The bill was passed by the Lok Sabha but rejected by the Rajya Sabha. A joint sitting was held on 16 May 1978. 22 The bill was passed by the Lok Sabha but rejected by the Rajya Sabha. A joint sitting was held on 26 March 2002. The bill was passed when 425 members voted for it and 296 against. 23 N. Malia, Indian Parliament, p. 39. 24 Keswananda Bharti v. State of Kerala, 1973. Minerva Mills v. Union of India, 1980. 25 In 1977, the 6th Lok Sabha expelled Mrs. Indira Gandhi from its membership and sentenced her to jail for a week for committing a contempt of House while she was Prime Minister. But, the 7th Lok Sabha rescinded the resolution expelling her by describing it as politically motivated. In 1990, a former minister, K.K. Tiwari, was reprimanded by the Rajya Sabha. 26 Article 121 of the Constitution says that no discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of the judge. Under Rules 349 to 350 of the Lok Sabha, use of unparliamentary language or unparliamentary conduct of a member is prohibited. 27 Call and Shaka, Practice and Procedure of Parliament, 1st edition, p. 157. 28 Thomas Erskine May, Parliamentary Practice, 15th edition, p. 109. 29 Subhash C. Kashyap, Our Parliament, National Book Trust, 1999 edition, p. 241. 30 Thomas Erskine May, Parliamentary Practice, 16th edition, p. 43. 31 The then Law Minister gave the following reason for dropping reference to the British House of Commons, that the original provision there was no escape from it had referred to the British House of Commons. Now a proud country like India would like to avoid making any reference to a foreign institution in its own solemn constitutional document. Therefore, this verbal change is being introduced so that there may not be any reference to a foreign institution. 32 A.V. Dicey, Introduction to the Study of the Law of the Constitution, Macmillan, 1965 edition, p. 3940. 23 Parliamentary Committees. Meaning. The Parliament is too unwieldy a body to deliberate effectively the issues that come up before it. The functions of the Parliament are varied, complex and voluminous. Moreover, it has neither the adequate time nor necessary expertise to make a detailed scrutiny of all legislative measures and other matters. Therefore, it is assisted by a number of committees in the discharge of its duties. The Constitution